you eligible to become a U.S. citizen? If you've gotten your green card, great, fabulous, wonderful. I know it's a long haul to get that green card, no matter which way you got there. And a lot of couples are then asking, okay, what's the next step? When do we get to actually become a U.S. citizen? And there's a lot of confusion because some people are eligible at 3 years and some people are eligible at 5 years. So I want to quickly go over, which is which and how you know which one you are eligible for and when you can file, for those different timeframes. So the general rule in the U.S. immigration laws is that an immigrant has to have a green card for 5 years before they can become a U.S. citizen, before they can, become a U.S. citizen through the naturalization process. There are several different types of exceptions. The type of exception that would apply to our client base here, which is people who are in relationships or have maybe started their immigration process in a relationship, even though the relationship may not have lasted, unfortunately. If you are on a marriage-based track, if you have been continuously married to the same U.S. citizen for 3 years, while having your green card, while meeting all of the other requirements to become a U.S. citizen, then at that point you can actually become a U.S. citizen early as 3 years. And it would be 3 years from the date on the very first green card you got, whether it was conditional or just a regular 10-year green card. So either your 2-year or your 10-year green card, the date that it says resident since this date, that's when you start counting the time. So if you're in a situation where you're approaching the 3 years and you've been continuously married and, having a relationship with that same person, if you've separated and are living in different houses or something like that, you definitely wouldn't want to try the early exception. You can just wait for the 5 years. But let's say you're in that situation, you can actually, that you can try for the 3-year exception. You can actually apply a little bit earlier in anticipation of getting to those 3 years. So when you get to the 90-day period before you reach the 3 years, so basically 2 years and 9 months before you meet the 3 years, then you can actually submit your naturalization application. So this is something you want to start thinking about when you're maybe like at 2.5 years of having your green card. You can start looking for an attorney or figuring out how you want to do the process to make sure that you can do it as soon as possible, which for a lot of people married to a U.S. citizen continuously is 2 years and 9 months. If you're in a situation where your relationship has unfortunately broken down, maybe you even have to apply for your removal of conditions using a waiver because you're not with your spouse anymore, something like that. You can, in those cases, you can still become a U.S. citizen as long as you keep your green card, but you just simply have to wait for the 5-year mark. So you just, it's not that they're punishing you, it's just that they're not giving you a special exception either. That is not true in some cases of domestic violence where you actually received your green card yourself due to being in a dangerous relationship where you were abused. You actually, in some cases there, can also use the 3-year exception. So just FYI, that's the story about the 3 versus the 5 years, and hopefully that gives you some clarity. If you need additional clarity, we're always free for consultations to help you with that as immigration attorneys.